whenever I come to these conferences, whether I'm speaking or somebody else is speaking, we talk about what's going on in the bankruptcies, but we don't talk about how the trusts that a lot of the courts are dealing with today are actually created, and what they mean, and how the claims are processed through them. So let me begin by starting from the beginning and telling you how a asbestos trust is formed and created in bankruptcy. Well, pursuant to Section 524G of the U.S. Bankruptcy Code, which is a special section specifically created in the Bankruptcy Code and enacted for asbestos companies with asbestos liabilities that are forced into bankruptcy. This came about because after Johns Manville, the biggest asbestos company in the world, went into bankruptcy in 1982, and then the plan was confirmed, I believe, in '86. The trust became effective shortly thereafter. The board of directors and their counsel weren't quite sure that the company got the protection and closure they needed from that bankruptcy. So it would have been pretty bad having emerged from bankruptcy, having created a trust for asbestos claimants, getting sued again for different asbestos liabilities. So they went to Congress and they showed them the existing bankruptcy law and said, look, we have this Section 524G that we believe gives an asbestos company that takes its assets and creates an asbestos trust for both present and future claimants, protection from all asbestos liabilities, personal injury, property damage, wrongful death. And Congress said, you know what, that makes a lot of sense to me, to us. We're going to enact it. So 524G ended up being enacted in, I believe, 1993. And this is the mechanism that an asbestos company will file bankruptcy for under. And the trust will be created. All of the asbestos liabilities will be channeled into a 105 injunction, and all present and future claims will be paid out of the trust, which is funded by the assets in the estate of the debtor. So the companies are protected, and the claimants, both present and future, have money in the trust that will take care of them. The bankruptcies are filed and litigated in both the U.S. Bankruptcy Court and the U.S. District Court. Both the U.S. Bankruptcy Court and the U.S. District Court have to confirm the plan of reorganization, which is unusual. This process of creating the trust begins with the actual filing of the bankruptcy. The U.S. trustee for the bankruptcy court will appoint different creditors committees. And the first one that they usually appoint is the Asbestos Claimants Committee. And that will be, usually it will be a claimant. The claimant is actually the designated committee member, but it's their lawyers who the trustee knows have been litigating against that debtor and have experience with that debtor actually serve on the Asbestos Claimants Committee. And it's usually about 5 to 8 lawyers for the plaintiffs. And that's the Asbestos Claimants Committee. Then there's an equity or shareholder committee. There's a bondholders committee, and there's usually a bank committee. And that's when the fun really begins. The litigation process begins between those different committees, and hopefully there are negotiations. The issue is, how do you divide up the debtor's estate, their assets, and who gets what? And there's issues of how much is the asbestos liability, what secured debt is there, what unsecured debt is there, how much is the bank debt, how much is the bondholders, what's it worth. So you could see that there could be a lot of litigation with respect to that. But fortunately, and the goal here is to have a consensual plan, to file a joint plan of reorganization. And that, fortunately, thanks to people like Mr. Cooney, that happens quite often. And believe me, it is a very difficult task. And that's why sometimes it takes 5, 6, 7 years. If you're not successful, if we are not successful in negotiating a consensual plan, then the case is litigated and there's an estimation hearing where usually both the bankruptcy court and the U.S. District Court will sit together, and the asbestos liabilities are tried to determine what is the value of the asbestos liabilities, and then the court will render a decision. But fortunately, that has only happened a couple of times.